Welcome to Court Helicopter News Explainer, where we are looking at the terminologies used in court. Today we are starting with the letter N, and the first word is negligence. You hear it every day. You are negligent. What does that mean? It means below the established or expected standards. Doctors have a certain level of duty and care to a patient. If they fail short, then they are held liable for being negligent. Drivers on the road, you have a duty to take care the lives of the pedestrians, to take care the life of other motorists, whether on a boda or a mkokoteni. That care, when you are careless, you become negligent. Then you'll be arrested and be charged for being negligent. Lawyers have a duty to their clients. So when they fail, then they are taken to the Law Society of Kenya Disciplinary Committee for being negligent. So anybody who does not do to the expectation required, then that is what we call negligence. That is a very serious education for you today. After negligence, we move to letter O. Letter O has the first word called oath. That is giving any statement under an oath. You swear that you will tell the truth. Every time you go to court, you see, you are told, swear. Anytime you appear in court to give evidence, you swear. Anytime the president takes an oath of office, he swears. Anytime the chief justice takes an oath of office, he swears. Anytime a cabinet minister takes an oath of office, they swear. So swearing is that you take an oath to defend, or you take an oath that you will say the truth. And remember, we said those marriage certificates, those marriage affidavits that were there, where you swear an affidavit on oath that you are married to so and so, are no longer part and parcel of the law. You must get a marriage certificate. Then we have the opening statement. An opening statement, for example, is where the lawyer explains in a very short, concise manner what he wants the court to know. What is the case of their client and why are they seeking this, in a summary. Opening statements are meant to sway the court to see the angle each lawyer or each party in court wants the court to see. Opening statements can spoil your case or they can win your case. It is what catches the attention, the eye of the judge, the eye of the magistrate, the eye of the Kadhi's court. Then we have what you call order. You have an order. Have you been served with an order? An order, courts speak through orders. Court gives directions through orders. The orders are specific. So and so do this. An order to the bank says, let Omari not access his money. That's an order. An order to stop you from traveling out of the country. Immigration will be served with that court order. An order is a document, a paper that the judge has given directions. They have been reduced into an order, and that order is served on the person who is supposed to be served. So courts don't deal with any other directions. They issue court orders. Let us go to letter P. What does letter P? we have what is called a party. Party, remember we talked about the litigants. Parties are those people who are in court. You'll see they are either called petitioners, they are called respondents, they are called defendants, they are called whichever term that they are called. Those are called parties. Even interested parties, these are people who are there. An amicus curiae, which we dealt with, is a party in a proceeding in court. Then we have perjury, the act of lying or stating falsely under oath. If you are in court, you are expected, after you have been sworn, to tell the truth and the truth alone. If you are found to be lying, it is an offense, and it is called an offense of perjury. You'll be arrested and you'll be charged for having lied on oath. So whenever you go to court, watch court helicopter videos. Every time in court, you must tell the truth. Then we have the petition. This term petition is a very, very serious issue. Petitions are papers taken to court, especially on constitutional matters, especially on judicial review matters. It is a way to go to court. You go to court through petitions. Petitions are found in the High Court. You cannot file a petition in a magistrate's court. Petitions deal with such heavy matters that are not easy. So, you initiate a proceeding by way of a petition. If you are not an advocate, don't try to file documents without knowing. A petition has where it is taken. An originating summons has where it is taken. A plaint and other things have specific things to be pleaded there. Then we have the person, the petitioner, is that person who goes to court. For example, you have seen Sheria Mtaani. They are petitioning the court to get certain reliefs. You have seen Okiya Mtata. They are petitioning the court. So the person who goes to court becomes the petitioner. If you are the one aggrieved and you want a petition to be filed, you become a petitioner. First petitioner, second petitioner, third petitioner. This is the person who has gone to court to seek for a certain favor. Then we have the plaintiff. Equally, a plaintiff is a person who goes to court in a contested matter. I said, once you go to court under different titles. You go to court as a petitioner. You can go to court as a plaintiff. You can go to court in very many terminologies. Then we have the word pleadings. Pleadings are the papers you take to court. Either you have a plaint, you have a verifying affidavit, you have a supporting affidavit, you have a replying affidavit, you have affidavit of means. All those papers that the judges look at from both sides are called pleadings. They must be sworn, they must be commissioned, and they must be dated when taken to court. Those are called pleadings. Then we have the power of attorney. A power of attorney, we dealt with it on the land matters, is when somebody has been given permission to go to court on behalf of another person. For example, your brother is in the US, your wife is in the US, your mother is unwell, you get the power of attorney to represent that person in court. That is what is called the power of attorney. And remember, the power of attorney must be registered by the Ministry of Lands. Don't pretend that you have power to represent somebody if you don't have a registered and recognized power of attorney. Then we have precedent. You hear every other time, President. You have listened to the decision of the Supreme Court when Raila Odinga the late and William Ruto were in court, or when Uhuru Kenyatta and Raila Odinga were here. Then the judges will here say, in a decided matter, R versus so and so in Britain, in Kinyanjui versus Kinyanjui, in Ruto versus Raila, all those authorities are called precedents. What is a precedent? A decision of a higher court always binds the lower court. So, anytime you go to the magistrate's court, you are arguing, you hear the magistrate say, in a decided case in this matter in the High Court Eldoret, these were the similar facts, the court said as this. If you go to the High Court, the High Court will be relying on decisions of either another High Court or decisions of the Court of Appeal or the Supreme Court. If you go to the Court of Appeal, they will always be relying on authorities of the Court of Appeal and the authorities of the Supreme Court. That is the hierarchy of the judicial system. There are 4 layers. 3 layers make precedents: High Court, Court of Appeal, and the Supreme Court. 2, Kenyan courts will rely on precedents of other countries. Decisions of South Africa, decisions of the Supreme Court of India, decisions from any other country will be bound, will be part and parcel of good law in this country. So a precedent is already what has set pace, and you cannot change that. Then we have proceedings. You hear every other time proceedings. Proceedings is what the judge records that transpires in court. You have seen whenever the prosecutor is talking and the witness is talking, the advocate is asking questions, the magistrate or the judge or the judges are recording. What they are recording is what is called a proceeding. That proceeding, after the hearing is over, it is available for you. You can apply, but you must pay to get proceedings, what really transpired in court. Courts record everything. We have now seen a new method of recording proceedings, the digital method of recording proceedings, where the judges have machines that record those proceedings. Then those recordings are transcribed. They become proceedings. You can access those proceedings in real time. So, anytime you want to know really what happened, you check the proceedings. That is the accurate. When you want to appeal, you must attach a copy of the proceedings to the court you are appealing to. Then we have the process. The process is called the due process. The process is the criminal justice process, the civil processes, the commercial processes. The whole process in court is called a process. Equally, processing can be when you have been arrested and the DCI takes your fingerprints, takes your facial hearings, takes your statements, you are being processed to be brought to court. So, the processing of an accused person to be brought to court by the investigative agencies, the process in court until the end is called the processes. Lastly, the word purge. What does purge mean? If the court has ordered you to do something and you fail to do, the court issued orders, you refuse to comply, then an application for contempt is filed against you. They want to jail you. They want you to pay. Then the court will say you must purge that contempt. You cannot be allowed to address a court if you have not complied with the court directions. So today, you now understand, whenever you have been served with a court order, don't ignore that court order. Comply first, then run to remove those orders. A purge is very risky. You might easily find yourself going to prison. Let us deal the last letter in this episode, letter R. Letter R has the first word called recuse. What does recuse mean? This is an application by somebody who is a party in court who is not happy with the judge or the magistrate. Then you make an application that I'm not happy with you judge. Wewe sina imani na wewe. Jiondoe kwa hii kesi yangu. I want another judge. You are biased. I don't like this court. Remember the case of the former deputy president, Rigathi Gachagua. He tried to remove the 3 judges that they must walk out from his case. They refused. The judges can refuse and insist to produce. So an application for recusal is not an automatic that it can be granted. It can be rejected. Then we have relief. Relief, these are the prayers you are seeking for. What is it you want? As a parent, you want school fees paid for your children. That is what the relief you want the court to do. Auctioneers have advertised to auction your building because you have not paid the bank. You go to court seeking for relief to stop that auction. So a relief is what you go to look for. Gachagua went to court saying the impeachment was wrong. He wanted his seat as the deputy president reinstated. That is the relief he wanted. Raila Odinga went to the Supreme Court saying the elections and the IEBC declared President William Ruto not rightfully. He wanted the court to, the relief he sought is to nullify the election of His Excellency the President William Ruto. He lost. So the court did not grant him the reliefs that he wanted. Then we have the word remand. Remand has 2 meanings. Remand can mean where somebody who has been charged with an offense, if he is denied cash bail by a magistrate or by a judge, he will be taken to a remand prison. Remand, you'll stay there until you pay cash bail or your case is finished. You are not a convict. You are a remandee. Another meaning for remand is where a high court sends a matter from the high court to the lower court that go there for further proceedings. It remands there. Then we have a very famous terminology, a reply. A reply also is a replying affidavit. You have heard lawyers saying, I'm filing a replying affidavit. A replying affidavit is an answer to what the petitioner filed. The person who accuses you, when you are responding, you are doing a replying affidavit. If it is a divorce, he will file a divorce petition. You will do an answer to the petition. So anytime you are sued, anytime you are taken to court, you respond by filing responses. Res Judicata. Res Judicata means the question you want the court to decide has already been decided by a different court. So what you are bringing here has already been done. You are only wasting time. This matter was heard in Kericho High Court. So what you are telling here in Milimani, they will tell you already a decision has been made in the High Court of Kericho. So res judicata means there is nothing new that is going to be heard. Two, the res judicata aspect is that the parties are the same. For example, you file a succession matter in Kericho or in Nyamira, you lose. Then you rush to Makueni and file suing your same brothers, same sisters over the same property of your deceased father. The court will tell you this matter is res judicata because it went to before the Nyamira High Court or Nyamira Magistrates Court and the same decision has been made. Then we have a respondent. A respondent is a party in court. The person who files is a petitioner, is an applicant, is a plaintiff. The person who has been sued is called a respondent. You are responding, you are a defendant, you are the person who has been dragged to court. The terminology you get is you'll be called a respondent. Then we have what you call a sanction. Sanctions are penalties the court gives. For example, after you have been found guilty, the court can give sanctions. You go to prison for 10 years. That is a sanction. Two, you pay a fine of 5 million shillings. That is a sanction. Three, the court can say you be evicted from that land because the land doesn't belong to you. That is a sanction. So the sanction is the coercive power of the court to enforce its orders. It can order the OCS to do this. For example, a burial dispute, the court can sanction and say no burial until this case has been heard and determined. Then we have satisfaction. That is a proper answer after a lot of litigation. So the decision sometimes is also called a satisfaction. You have been told to do this, you have done it, you go to court and say, me, I have complied with the court orders to its satisfaction, then you are acquitted. If you start giving explanations, you'll go with sanctions. Then we have security of costs. Anytime you lose a case and you appeal, you must deposit security of costs. Remember, in these by-elections that happened, anybody who was declared the winner, if anybody goes to make an appeal to challenge the election of those MCAs, those MPs, that senator, that person who is challenging must pay security of costs as a deposit. For the MCA, you must pay to the court 250,000 shillings. To the MP and senator, you must pay 500,000 shillings. For the presidential election petition, you must pay a deposit of 1 million shillings. If you lose, this is given to the person you have sued. So, security of costs. Make sure any appeal, you must pay that to the court. So that if your appeal is useless and you lose it, then the person you dragged for appeal will get those costs. Then we have what we call service. I want to be very, very clear. Service. This is death. Service means the court has ordered you be served. A person has gone to court and sued you. The court will always say, serve that person that you have sued. Formerly, service was physical. Somebody must look for you, come where you are, tell you, I have these court papers. The law changed. Nowadays, service is on email. If somebody sends you on email, and that email is the last email that they knew, that is proper service. If somebody sends documents on WhatsApp, and listen thoroughly, service on WhatsApp is valid. You cannot argue that I was never served. Service on WhatsApp, and I'm repeating, many of you, especially accident cases, you are served on WhatsApp, you ignore. Many of you claims you are in court. The court will proceed with the matter and judgment will be entered against you. Third, service can be done by that court document being put outside your gate, either in an office or in your residential place or in an area peculiar to you. That is service. Service can be done through substituted service, a newspaper advert that the court can allow. Don't tell the court you never read the Standard, you never read Daily Nation, you never read the Star. That is service. So, be very alert. If service has been done, a return of service by the court process server is filed in court saying they came, they served you, or they sent it on your telephone, on your WhatsApp, and you Bluetooth ticked. That is service. The court will proceed and enter judgment against you. Today, you know, anytime you receive any document from court, remember that document is very, very, very critical. We now look at show cause. The courts, after you have been cited for contempt, they will ask you to show cause. Show cause means come to court and explain why you didn't do what the court ordered. Some of you ignore to come to court and you are convicted for failure to come to court. Then we have statute of limitations. A very critical thing. Statute of limitations. There is an act that defines timelines. When somebody has done this, how long do you have to go to court? For example, in employment, if you have been sacked, you must go to court within 3 years. If 3 years lapse, you are wasting your time. The court will not allow your case. 2, if it is a question of contract, it is 6 years. So the law defines timelines to file a case. The matter for succession has no time limit. Whether your grandfather died in 1920, you can go to court now. Criminal matters have no timelines. If you committed a crime when you are 19 years and the DCI gets evidence when you are 70, you'll just be arrested and be charged. We have what is called stay. You hear people say, I am looking for an application to stay. Stay is a temporal halt. Kuweka break kidogo. For example, you are in the lower court, you are being charged, you rush to the high court to get a stay of the proceedings. Somebody has a court order to evict you, you rush to court to stay that court implementation of that court order. So a stay is a temporal relief, because you are saying, when these things were proceeding, I was never served, I was not aware. Stay execution until I challenge that. It is suspension for a certain small duration. Then we have a suit. Any matter in court, any civil, commercial, ELC matter is called a suit. Then we have summary judgment. This is summary judgment or default judgment. When you fail to defend yourself, the court will enter into a summary judgment because you are not there. Summons. Summons are documents to tell you you are required to come to court. Court will issue summons. If you are a witness and you fail to come to court, the court will issue summons. If you are an investigating officer, the policeman, the court, and you fail to come to court, the court will issue summons. If you are somebody wanted in court, summons will issue. 2, the land registrar issues summons for you to go to his office. A children officer will issue summons for you to go there. Parliament issues summons for governors to go to parliament. So summon is an official document to call you. Lastly, the word in S called surety. This is a person who comes to court and says, the accused person, I know him. I'll stand to guarantee that he will be coming to court. I have given my title deed. I have given my logbook of a car. I am ready to surrender that title deed or that land or that vehicle in case he disappears. Be very careful when you stand surety to somebody you don't know. Be very careful when you stand surety for somebody you don't know. Remember, surety is the same as a guarantor. A bank guarantee, a SACCO guarantee, a chama guarantee. Have you guaranteed somebody and he has taken money? He has disappeared. He has gone to Uganda. She has been married in Dubai. She goes away. You will have to pay that amount of money. Wakili Danstan Omari on letter S, which has a lot, letter P and S has a lot of terminologies in court. See you in the next episode. Thank you.